people.
Why should you say, oh? You start bumping into stuff, that's gonna be a problem. All right.
Get on from behind me, mister. What you stand behind me for, Alan? And started here, okay? Can I talk?
Not yet, ma'am.
Oh, okay.
Is there gonna be an attorney saying something?
Assistant Public Defender Mr. Davy Lee, Your Honor, on behalf of Ms. Tracy Reed. Mr. Miller has been appointed, however, I did speak to her about the bond violation.
Right away, this case opens with a defendant already on thin ice. Before we even get into the back and forth, one phrase changes the entire atmosphere of the courtroom. Bond violation. That immediately tells viewers this is no longer just about the original case. Now the court is looking at whether the defendant followed the conditions that allowed her to remain out of custody. Judge Simpson is about to examine not just what happened, but whether he can still trust her to comply moving forward. The defense quickly begins explaining missed appointments, work obligations, and communication issues. But those explanations only matter if the judge believes they show confusion rather than disregard. Watch closely because this hearing becomes a fascinating battle between accountability and second chances. At first, it sounds like a paperwork problem. A few minutes later, it starts sounding like a credibility problem. And when credibility becomes the issue, courtroom outcomes can change very quickly.
Whoever wants to argue.
Your Honor, Ms. Reed indicates to me that she did go do community corrections on the 11th. However, on the 12th, she was unable to remain as she had to go to work. However, she does come to understand that now it's important that she goes to community corrections, stays there until she is called, and there will not be any further violations.
But they did have the wrong number. They have the number from 2014. That's not my phone number though. She never asked me
They
for my
set
phone.
an intake appointment for December 2nd. Did you go?
No, sir.
Why?
When I went on the first, I explained to the lady that I just received the job. I gave him the intake paper that I gave the judge when I got arraigned. I told the lady, I said, listen.
And go ahead.
Well,
Go ahead.
I asked her, could I come at a different time? She told me that that was the time and I needed to call to see if I could get enough time. Every time I called, I didn't ever get to her. So no, I didn't go back.
What do you mean every time? Every time you call,
I called her twice.
how come you didn't go back up there?
Because I don't know, Judge Simpson. I ain't gonna lie.
So I have no test results.
No, I took the test results is right here. I took the urine.
Well, the one, yeah. But since then, I don't have anything.
He only told me to drop once a month. He told me to go once a month and drop.
That's correct, but how were you going to go back if you didn't do the intake?
This is the moment where Judge Simpson cuts through all the noise and gets directly to the core issue. The defendant keeps focusing on the drug testing requirement, but the judge is focusing on the process. From the court's perspective, the intake appointment is not a minor administrative detail. It is the gateway that allows the entire supervision system to function. Without completing intake, community corrections cannot properly monitor compliance, schedule future testing, or communicate expectations. Notice how the judge keeps asking simple logical questions instead of making accusations. That's often a sign that the court is testing whether the explanation actually holds up under scrutiny. The problem for the defendant is that every answer seems to create another question. Was it confusion? Was it misunderstanding? Or was it simply failure to follow instructions? Viewers, what do you think at this point? Does this sound like a genuine mistake? Or does it sound like someone who underestimated how seriously the court would take these requirements?
I didn't know I had to do the intake in order to keep dropping.
What?
I didn't know that I had to do the intake in order to keep dropping because I didn't do the intake.
How are you going to know when to?
on the 1st.
You have to do the intake. So that then they will then tell you when to test.
Okay.
You understand that?
Yeah, but I was assuming that since I had to go on the 1st to drop, I only got to drop once a
See,
month.
here's
I'm
the
thinking
problem.
every month on the
And
1st.
that is, if you had gone on the 2nd, they would have been able to explain all of that to you, but you didn't go.
Yes.
So, Ms. Reed, tell me why I shouldn't just lock you up because you didn't comply with your bond.
Jesus, please.
Tell me why.
Because I'm going to the next one. I went over there this morning. I came in at 9. I thought my court date was at 9. I came. They told me it was at 1. I went up to community corrections, and they told me that they couldn't do that. I had to get another
Stop talking. Just
referral.
stop. Because you're gonna say something. And it's just gonna get bad.
Oh, Jesus.
No, it's Judge, but that's okay. You're enjoying that gum, aren't you? That gum is taking a beating.
You're making my nerves bad. Got the police standing behind me like he about to handcuff me. I'm sweating. I can't go to jail. I
No,
can't.
you can.
I'm too old for that. I can't. Please. No. Please, no, sir. Your Honor, Judge Simpson, please. I just got my good job. No.
Okay, at least the one benefit is you're on, and the only thing that I'm not gonna lock you up today. The only reason I'm not doing is run monthly. You're still within that month, and the test that you took was negative.
Absolutely.
This is a huge turning point in the hearing. Just moments earlier, the possibility of jail felt very real. The defendant was visibly nervous, emotional, and openly pleading with the court not to lock her up. Then Judge Simpson reveals the factor that likely saves her, the negative test result, and the fact that she is still technically within the monthly testing window. That's important because judges often look at both violations and overall compliance history. Here, the defendant clearly failed to complete intake, but there is also evidence that she was not actively failing drug tests. That distinction matters. Instead of viewing the situation as outright defiance, the judge appears willing to view it as incomplete compliance that can still be corrected. The tension immediately drops, but not entirely. The warning signs are still there. Judge Simpson is essentially saying, "I'm giving you another chance, but don't mistake this for unlimited patience." The courtroom mood shifts from punishment to opportunity, and now everything depends on what happens next.
But then you didn't do this. You take the next test.
Okay. I'm going over there right now.
So let's. I'm going to prepare new orders. I'm going to adjourn her probable cause to January 2026, 9 a.m. We'll do a new community corrections referral for testing. You stay over there today when you go over until you complete that intake.
Okay.
You hear me?
Yes,
Because if
sir.
you come back here and you haven't done the intake, there's nothing you're going to be able to say to me.
Okay. Now I have another question.
Oh.
Before all of this happened, I had plans to go out of state for New Year's. So I need the permission to go because this has been planned and paid for.
Just when it seems the bond violation discussion is wrapping up, the hearing takes a completely unexpected turn. The defendant suddenly asks for permission to travel out of state for New Year's. From a retention standpoint, this is the kind of courtroom moment nobody sees coming. Seconds ago, she was begging not to go to jail. Now she is asking the judge to approve a vacation request. Legally, the request makes sense because travel restrictions are often part of bond conditions, and leaving the state without approval can create serious problems. But from the judge's perspective, the timing is almost unbelievable. The court is still discussing compliance issues, and now the conversation shifts to holiday travel. You can already feel the skepticism building. The judge wants details, wants specifics, and wants reassurance that she will actually return. The stakes may sound smaller than a bond violation, but they are directly connected. Trust is the currency here, and every answer she gives either increases or decreases the amount of trust she has left.
Where are you going?
To New York to watch the ball drop.
You are not. No, you're not. You are not. No, who is that? I don't know who she is. I don't believe her. You're gonna go watch the ball drop.
Yeah.
Where?
From what's the name of it?
Like Times Square?
Yes, down by Times Square. We stand in a room.
There's a whole lot of rooms by Times Square.
Yeah, I don't know right now. My nerves bad, I'm telling you.
You're gonna go watch the ball drop.
Yes.
Are you gonna be outside watching the ball drop?
Not if it's real cold. I'm hoping we can see it from the
It's
hotel.
gonna be cold.
But it might not be that.
Have you ever been there?
No, that's why I want to go.
She has never been around that many people.
In my life.
Yeah, I know. And you have no idea what that's like.
But I want to go.
I know. And I have a feeling if I let her go, she ain't coming back. She's gonna be lost someplace in New York.
No, I'm coming back.
When are you supposed to be leaving?
What day we leave?
So you don't even know. How do you not know? How do you not know when you're
Because
leaving?
I work and she take care of all the business. Now we leaving on the 30th.
When are you coming back? Well, never mind. When are you coming back? On the 7th?
Second.
2nd. Hold on a minute. So you're going to New York basically for just a few days.
Yeah, just to see the ball drop.
I'll tell you how you can see the ball drop.
I don't want to watch it on TV.
This exchange perfectly captures why Judge Simpson's courtroom clips attract so much attention online. The hearing suddenly transforms from a compliance discussion into a surprisingly funny debate about New Year's Eve in New York. Beneath the humor, though, there is a serious judicial calculation taking place. The judge is evaluating risk. Will she return? Does she have legitimate plans? Is she being honest? The defendant remains persistent, insisting she wants the real experience and not a television version of it. What makes this scene so entertaining is the contrast between the two sides. The judge is skeptical, practical, and clearly amused. The defendant is determined, excited, and completely unwilling to abandon the trip. Viewers, would you have approved this request if you were the judge? Remember, this is someone who just spent much of the hearing explaining why court requirements were not completed. Granting travel permission requires confidence that those same issues won't continue once she leaves the state.
That's what I was going to say.
Yeah,
You can see the ball drop.
It's already paid for. We can't get the money back. I don't want the money back anyway. I want to go. But I have to have permission. Because if I get stopped and then they be like, oh, you're stopped, and they try to take me into custody. No. Just me making my nerves
If I
bad.
could just lock you up, you wouldn't see the ball drop.
Okay, so here we go. You just said you were gonna lock me up. Now you want to go back to that incident. I'm not gonna do that. Just
Counsel, whichever one's representing you, prepare an order to the effect unless there's an objection from the people to let her go watch the ball drop.
She's got permission to take the time off of work.
I don't-
Wow, whoa.
Excuse,
Came right at you. No, that's a legitimate question. Thank you, counsel.
excuse me, I don't go back to work until January the 5th.
Oh, so you had time to stay in. Why'd you tell me you didn't want to lose
That's
your
all for
job?
Christmas, Your Honor. That ain't now. That's all for Christmas. The last day is the 23rd. Today's the 11th. My glasses back on. Why you keep walking by me? Stay away
You know
from me.
what? Take those glasses off. You don't need them.
They my safety guys. My told you my nerves back. The police keep trying to come over here.
I got it.
So I can go?
Are you driving?
Yes, we're gonna drive.
She gave an adequate answer to the work question. You're gonna drive
Yes.
through Canada, or you just going straight through the States?
I'm going through the States. I'm off to the 5th. We're gonna,
Yeah, because if you go over that border, you ain't getting back. All right.
Okay. So who gonna give me the paper saying I can go, or I can just?
I will prepare the
You know
order.
what? She needs to stop asking me questions.
I'm gonna prepare an order to,
I've already prepared the order because you were taking so long.
thank you, Your Honor.
Bye.
Okay.
I don't know what happened either, but God bless New York. Court calls the case People versus Connor Rice.
What started as a potentially serious bond violation hearing ends in one of the most memorable and lighthearted exchanges of the day. After all the confusion surrounding intake appointments, testing requirements, missed follow-ups, and concerns about compliance, Judge Simpson ultimately chooses accountability over incarceration. He does not ignore the violations, but he also does not impose the harshest consequence available. Instead, he orders a new community corrections referral, reinforces the intake requirement, schedules continued oversight, and even grants permission for the New York trip. The key takeaway is that compliance matters, communication matters, and credibility matters. The defendant came dangerously close to losing her freedom, yet a negative test result and the opportunity for corrective action helped keep her out of jail. At the same time, the judge made it crystal clear that future excuses would not carry the same weight. The case serves as a reminder that second chances exist, but they usually come with strict expectations attached. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.